Good afternoon. Happy Sunday. I've had a lot of questions about recording in public buildings ever since someone attempted to G-check me, I think is the current operative word. Anyway, I figured I would address it somewhat. There are different circuits. I just want to caution everybody, this is a very high-level view of it. I am not going into a specific case in a specific circuit. So take this all with a grain of salt. Some circuits are much more liberal. They have a more robust jurisprudence on what is and isn't allowed. And they've developed tests that are more or less lenient. Other circuits have very little jurisprudence. And so take this all with a huge grain of salt. But the first thing that you have to determine is whether or not there is in fact a prohibition in place on recording. This is Gericky versus Begin, and in this case, admittedly, it was where a woman was recording a traffic stop from a public place. The court analyzes this and says, look, there has to be some sort of a prohibition in place in order for recording to be prohibited. This conclusion follows inescapably from the nature of the First Amendment right, which does not contemplate self-censorship by the person exercising the right. The conduct prescribed must be defined specifically so that the person or persons affected remain secure and unrestrained in their rights to engage in activities not encompassed by the restriction. The appellant had a constitutional right to address meetings and organize parties, unless in doing so he violated some prohibition or of a valid statute. Such restrictions could take the form of a reasonable contemporaneous order from a police officer, or a pre-existing statute, ordinance, regulation, or other published restriction with a legitimate government purpose. So what this is saying is that in order for you to start down the road of being prohibited from recording, there has to actually be a prohibition in place. This is Dunn versus the City of Fort Valley. This is this is a district court decision out of the 11th Circuit. The First Amendment, so in this case, Dunn went into City Hall and he was recording from a place where he was allowed to be, and there was no prohibition in place on him recording. There was no sign posted, there was no ordinance in effect, and he was recording things in there. And so the court said the First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest. Individuals have, under the First Amendment, the right, subject to reasonable time, manner, and place restrictions, to photograph or videotape police conduct. Moreover, the 11th Circuit precedent holds that the law enforcement officers may not arrest an individual as a way to thwart or intrude upon First Amendment rights otherwise being validly asserted. Thus, a plaintiff plausibly states a First Amendment violation by alleging he was arrested for documenting the activity of public officials on public property. Citing Bowen versus Superintendent of Miami South Beach Police Department, holding that a plaintiff had plausibly stated a First Amendment violation by claiming he was arrested for taking photographs of alleged police conduct, and the police then deleted the photographs he took. In evaluating Mr. Dunn's First Amendment claim, the court must first examine whether the defendants are entitled to qualified immunity. Again, Mr. Dunn concedes the defendant's actions were discretionary. Thus, the court moves on to address whether Mr. Dunn's First Amendment right was clearly established and whether the defendants had violated that right. The case law cited above easily demonstrates that the right to record public officials on public property is a clearly established First Amendment right. The complaint clearly alleges that Mr. Dunn exercised his First Amendment right in a peaceful manner, and accepting that as true, the defendants lacked the authority to stop him. There was no sign or other indication of a policy prohibiting the public from taking photographs, and in fact there is no policy regarding photographing in public areas of government buildings in Fort Valley, Georgia. Therefore, qualified immunity does not apply to this count either. The court denies defendant's motion to dismiss. And again, I just want to point out that even though it's talking about police officers, he was, let me get up in here. Do. All right. While Mr. Dunn was filming in City Hall, he drew the attention. Well, let's read it back. So, on July 9th, 2018, Mr. Dunn intended to produce a segment for his broadcast regarding missing persons in the Fort Valley, Georgia area. Mr. Dunn began his report by taking footage of the gazebo and other monuments on downtown Main Street. He then proceeded to the Fort Valley Police Department. Mr. Dunn took photos and videos inside of the historic police department building and on the grounds and around the grounds. The purpose of this footage was primarily to serve as B-roll for his report, but also to evaluate the building's accessibility for people with disabilities, as Mr. Dunn is himself disabled. Several officers noted Mr. Dunn filming there but did not speak to him. Mr. Dunn then proceeded next door to Fort Valley City Hall. He again took photographs and video of the inside of the building, including the missing persons posters on the public service announcement board. Mr. Dunn, impressed to see a city official hard at work, shot additional footage from a distance of the mayor outside her office, or inside her office. At all times, Mr. Dunn was only present in the publicly accessible areas of the City Hall. So he did not get jammed up for filming a police officer. He got jammed up for filming the mayor from publicly accessible areas of City Hall. But there was no prohibition placed on doing it, and so the officers can't restrict his First Amendment because there was no restriction on his First Amendment. There was no policy in place. If there is a policy in place, or if the court wants to put a forum analysis on it, you have Dyer versus Smith. In Dyer versus Smith, the plaintiff and the plaintiff's husband, gay couple, but I don't know if that really matters. So Mr. Dyer and his husband were traveling, and Mr. Dyer's husband was getting a pat down, and Mr. Dyer decided to film it. The TSA didn't like that, made Mr. Dyer delete the recording, which he then subsequently recovered after getting on the plane. So he sued, and here we are. So the question before the court, we're in the Eastern District of Virginia now. The question before the court is, was there a First Amendment right? Did Mr. Dyer have a First Amendment right to be filming inside of that airport? He's in an airport now, kids. We have the International Society of Krishna Consciousness versus Lee, and Lee versus the International Society of Krishna Consciousness. We have both of those, and now we get to figure out whether or not the TSA can stop you from recording, right? So the court first considered blah, blah. So the First Amendment guarantees that Congress shall make no law abridging the freedom of speech. As the Supreme Court has observed, the First Amendment goes beyond protection of the press and the self-expression of individuals to prohibit the government from limiting the stock of information from which members of the public may draw. An important corollary to this interest in protecting the stock of public information is that there is an undoubted right to gather news from any source by means within the law. Courts across the country agree that, incident to the right to gather news, citizens have some right to record government officials in performing their jobs. The 11th and 9th Circuits recognize a broad right to record matters of public interest. The First Circuit acknowledges a right to record government officials engaged in their duties. 4 other circuits recognize a narrower right to record a subset of government officials, law enforcement officers, specifically law enforcement officers. Considering this growing consensus, this court finds that the First Amendment protects the right to record government officials performing their duties. The First Amendment, however, does not offer absolute protection. The government can regulate activity protected by the First Amendment. The extent to which the government can impose such regulation depends on the type of forum in which the protected activity occurs. In a non-public forum, the forum at issue in this case, the government may impose reasonable regulations that do not arise from an effort to suppress the speaker's activity due to a disagreement with the speaker's view. Quoting International Society for Christian Consciousness, Incorporated versus Lee, or as the plot hole would say, Kirsten versus Lee, which held that the government can impose reasonable restrictions on speech in an airport operated by a public authority. Thus, the government can impose reasonable regulations on the right to record government officials performing their duties in Richmond's airport. Dyer accuses the defendants of prohibiting him from recording the pat-down search of his husband from about 10 feet away and ordering him to delete the video from his cell phone. Dyer says that his recording did not interfere with the screening procedure. Accepting the facts asserted by the plaintiff as true, the defendants demand that Dyer stop recording and delete the captured video plausibly constitutes an unreasonable restriction on the plaintiff's First Amendment right to record government officials performing their duties. So in this particular case, because it was a forum analysis, because it was specific to this particular forum, and because the forum was a non-public forum, all of a sudden it's a rational basis review. Is it a reasonable restriction? Is it viewpoint neutral? But what if it is broader than that? On the topic of these traditional public forum analysis, on the topic of Turner v. Driver and etc., there is a bit of a split, by the way. Filming public officials in the course of their duties. This is out of Colorado. This is a district court decision. I think Colorado's sixth? Is Colorado Sixth Circuit? I don't remember exactly. But in this, it goes down the same analysis that I have always gone down before. That the right to record what public officials do on public property is actually talking about traditional public forums. This is a public forum analysis. This has always been my thought. So this is Jed Kerr. He's a donkey, I think, or something like that, versus the city of Boulder. This is when him and a friend went to a jail and, like jackasses, tried to film on jail property. So alternatively, even if plaintiffs had a First Amendment right to film on jail property while on jail property, let me try that again. Alternatively, even if plaintiffs had a right to film jail property while on jail property, the court finds the individual defendants are entitled to qualified immunity because as of December 28, 2018, and still to this day, plaintiffs do not have clearly established First Amendment right to film on jail property as a non-traditional public forum. None of the cases cited by plaintiffs as purportedly showing a clearly established right to film involves a non-traditional public forum, whether a jail or otherwise. They all involve traditional public fora like streets, sidewalks, and similar public places. For example, in Turner v. Driver, the plaintiff was filming a police station from a public sidewalk across the street from the station. And then there's Smith versus Cummings. All videotaping of the police was performed from public property, all of which appears to have taken place on public streets, given that the videotaping was of police officers and police cruisers purportedly improperly stopping vehicles. In Bowens versus International or Superintendent of Miami South Beach Police Department, the plaintiff filmed police while on a public street and on a sidewalk adjacent to the activity. In Gericky versus Begin, the plaintiff filmed police officers who were on the side of the highway from her location in an adjacent school parking lot. In Frazier versus Evans, a decision postdating the events of this lawsuit, the filming occurred in a public parking lot. The 10th Circuit Court of Appeals held that I guess we're in the 10th Circuit right now. I didn't remember that Colorado's 10th Circuit. It's got to be 10th Circuit, though. That's right. Huh, whatever. I'm dumb. I don't know where Colorado is, what circuit it is. In the 10th Circuit Court of Appeals has held that the right to record the police performing their official duties in public spaces was not clearly established law until 2014, although it declined to state whether such a right has been clearly established since that time. None of these cases or any other cases cited by plaintiffs holds that they had a clearly established right to be on jail or similar property and film at will. Citing all these other cases that they probably cited, including old standbys like ACLU versus Alvarez, Glick v. Knief. What other ones are the big ones? Any other big ones in here? Fordyce. Here's Fordyce versus Seattle. Now, weirdly enough, Iacobucci was filming in a city hall. So apparently city halls aren't non-public forums, at least according to this court. Iacobucci was filming in the hallway of a city hall. So accordingly, they're entitled to qualified immunity. So that's my understanding of the right to film police, is that it's basically a right to film police in public property. But I could be wrong, and I hope I'm wrong, because there is a split. This is a Project Veritas Action Fund versus Rollins. This is a First Circuit 2020 Court of Appeals decision. And then what they're looking at is Massachusetts has I think this was Massachusetts. Massachusetts had a wiretap law. And this wiretap law, they were trying to say, allowed them to arrest or prosecute Project Veritas for recording police surreptitiously. Now we've already looked at what happens with at an instance where you can film the police when there's no restriction in a public building, or you could film inside a public building with no restriction. You could film inside of a public building based on a non-public forum reasonable basis, where the restriction is unreasonable. Now this is looking at a wiretapping statute that could be applied anywhere, but it's specific about recording police. They're saying that this is not going to allow us to record public officials. And so let's take a look at it. I thought I was where I needed to be. Here we go. Here's the First Amendment grounds. All right. So we begin with Project Veritas's First Amendment challenge to Section 99 insofar as it bars the secret recording of individuals who lack any reasonable expectation of privacy. In response to interrogatories from the district attorney, Project Veritas explains that it defines a reasonable expectation of privacy as a circumstances in which the parties to the communication may reasonably expect the communication may not be overheard or recorded. That vague yet sweeping definition, however, is problematic from the perspective of the ripeness inquiry. It fails to blah, blah, blah. Hold on a second. All right, here we go. Project Veritas's First Amendment challenge to Section 99's bar to the secret, non-consensual audio recording of government officials discharging their duties in public spaces arise from, where was it? God damn it. Was I actually at where I wanted it to be? Because we went on to ripeness concerns. All right. It's somewhere in here. All right. News gathering. Yeah, all right. So we were looking at Kerr, and Kerr was talking about Glick v. Cuniff as one of their cited sources. Glick v. Kniff, and also Gericky versus Begin. Maybe it talked about it earlier. Here we go. Gericky versus Begin. So they're looking at First Circuit decisions. Now, Project Veritas is also a First Circuit decision. And I just want to make sure I'm in the right spot. Yes, I think I'm in the right spot. So the plaintiffs challenge a restriction on their right to collect information rather than on their right to publish information that has been lawfully collected. But the First Amendment limits government regulation of information collection, as our decisions in Glick and Gericky show. See also Brandenburg versus Hayes, which said without some protection for seeking out the news, freedom of the press would be eviscerated. In fact, as we explain next, those decisions show that the First Amendment imposes at least some restrictions on the government's authority to bar the audio recording of police officers while they're discharging their official duties in public spaces. As we explained in Glick, the First Amendment's protection encompasses a range of conduct related to the gathering and dissemination of information. That is so, Glick elaborated, because the gathering of information about government officials in a form that can be readily disseminated to others serves as a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs. In recognizing the particular significance of First Amendment news gathering rights with respect to government, moreover, Glick noted that the state has a special incentive to repress opposition and often wields a more effective power of suppression. Glick explained in this regard that protecting the right to collect information about government officials not only aids in the uncovering of abuses, but also may have a salutary effect on the functioning of government more generally. Glick added that the justifications for protecting news gathering were particularly true when it came to collecting information about law enforcement officials. Based on these observations, Glick held the following. It ruled that the federal constitutional guarantee of freedom of speech protects the right to record, in quotes, government officials, including law enforcement officers. So it's not limited to law enforcement officers, but it includes it, in the discharge of their duties in public space. Even when the recording, which there involved both audio and video, is undertaken without the consent of the person recorded. Gericky then went on to extend Glick. There, the person attempting to record both audio and video was an individual whom the police had pulled over during a traffic stop, and thus, unlike Glick, she was not a mere observer to the police encounter that was recorded, but a participant in it. Further distinguishing the case from Glick, the recording at issue in Gericky attempted to capture an encounter that occurred on the side of the highway rather than in a public park. But even though the recording was attempted by a person the police had stopped in a location that was hardly a traditional site for a First Amendment expression, Gericky held that based on Glick that the recording at issue warranted First Amendment protection, at least to some extent. Indeed, Gericky reaffirmed Glick's broad formulation that the kind of recording that constituted news gathering and found that it encompassed the attempted recording there. Notably, Glick and Gericky accord with the decisions of several of our sister circuits that similarly have held that such recording warrants some degree of First Amendment protection as a type of news gathering. See, for example, Alvarez, finding that the challenged eavesdropping statute burdens speech and press rights because it interferes with the gathering and dissemination of information about public officials performing their duties in public. Fields versus the City of Philadelphia, recording police activity in public falls squarely within the First Amendment right to access of information, or of access to information. Smith versus Cummings, recognizing the First Amendment right to gather information about what public officials do on public property and to record matters of public interest. Fordyce versus City of Seattle, finding a genuine dispute of material fact as to whether officers had interfered with the plaintiff's First Amendment right to gather news. And while some courts of appeals have held that this right to record is not clearly established in some contexts for purposes of qualified immunity, see, for example, Kelly versus Borough of Carlisle, none has held that the right does not exist. It is true that these other cases, like Glick and Gericky themselves, concern the open rather than the secret non-consensual recording of police officers. But Glick described the scope of the recording activity that triggers a First Amendment protection as a type of news gathering capaciously as recording government officials, including law enforcement officers, in the discharge of their duties in a public space. Gericky then went on to use the same broad formulation, which does not exempt secret recording. The logic that Glick and Gericky relied on in setting forth in setting forth that encompassing description of First Amendment protected recording of police supplies strong enough support for understanding it to encompass recording even when it is conducted secretly, at least as Section 99 uses that term. To understand why, one need only consider the Hyde dissent's example of the recording of the beating of Rodney King. Like many recordings of police misconduct that have followed, the recording in the King case was made from a location unlikely to permit it to qualify as recording conducted in, quote, plain sight, end quote, of those recorded, just as the dissent in Hyde emphasized. But, as recent events around the nation vividly illustrate, such undetected recording can itself serve a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs, and not only aids in the uncovering of abuses, but also may have a salutary effect in the functioning of government more generally. Civilian video fills the gaps created when police choose not to record video or to withhold their video footage from the public. In fact, as the Martin plaintiffs point out, audio recording of that sort can sometimes be a better tool for gathering information about police officers conducting their official duties in public and thereby facilitating the free discussion of governmental affairs and uncovering abuses than open recording is. That is not only because the recording undertaken from a distance and thus out of plain sight of the person recorded will often be the least likely to disrupt the police in carrying out their functions. It is also because recording that is not conducted with the actual knowledge of the officer, even if conducted proximate to the person recorded, may best ensure that it occurs at all, given the allegations the Martin plaintiffs set forth about the resistance from official quarters that open recording sometimes generates. In sum, a citizen's audio recording of on-duty police officers' treatment of civilians in public spaces while carrying out their official duties, even when conducted without an officer's knowledge, can constitute news gathering every bit as much as a credentialed reporter's after-the-fact efforts to ascertain what transpired. The circumstances in which such recording could be conducted from a distance or without the officer's knowledge and serve the very same interest in promoting public awareness of the conduct of law enforcement, with all the accountability that the provision of such information promotes, are too numerous to permit the conclusion that recording can be prohibited in all of those situations without attracting any First Amendment review. We thus hold that the Martin plaintiffs' proposed recording constitutes a type of news gathering that falls within the scope of the First Amendment, even though it will be undertaken secretly within the meaning of the Section 99 statute. That such recording qualifies as a species of protected news gathering does not mean that Section 99's criminal bar against it necessarily violates the First Amendment. We cautioned in Glick that the right to record that was recognized there is not without limitations. We must thus determine whether the limitations that Section 99 imposes on this type of recording, conducted secretly as it will be, conduct or comport with the First Amendment. Glick had no occasion to explore those limitations because the audio recording of the officers at issue there occurred peacefully, from a comfortable distance, in a public space, and in a manner that did not interfere with the police officers' performance of their duties. But, although Glick made it clear that such peaceable open recording, which captured an arrest on the Boston Common, was worlds apart from the recording of a traffic stop, Gericky explained that the distinct concerns about public safety and interference with official duties implicated by such a stop did not, without more, extinguish the right we recognized in Glick. In fact, although Gericky recognized that the circumstances of a given police encounter might justify a safety measure that could incidentally constrain citizens' right to record, it held that a police order that is specifically directed at the First Amendment right to record police performing their duties in public may be constitutionally imposed only if the officer can reasonably conclude that the recording itself is interfering or is about to interfere with his duties. Gericky did recognize that the government might choose to regulate such recording in a more general ex ante manner, but it concluded that the government would need a legitimate governmental purpose to impose a limitation of that sort. Thus, in light of Glick and Gericky, we must decide whether the Commonwealth's interest in prohibiting conduct that interferes with police officers' ability to carry out their duties or some other legitimate government purpose justifies Section 99's ban on secret, non-consensual audio recordings of police discharging their official duties in public spaces. Before answering that question, though, we must decide how tailored Section 99's ban on the recording here seems to be to the legitimate governmental interest that the Commonwealth claims Section 99's criminal bar against recording at issue serves, or some other interest altogether. We must thus turn to the antecedent question, which sounds in the familiar vernacular of level of scrutiny. The district court agreed with the Martin plaintiffs that 99's ban on content is content neutral because it prohibits secret recording without regard to the topics or ideas recorded. They said Section 99 is a content neutral law of general applicability. Accordingly, the district court also agreed with the Martin plaintiffs that strict scrutiny would not be appropriate. The district court expressly pointed out, however, the defense did not develop an argument that a lower standard than intermediate scrutiny should be applied, as they merely suggested that such a lower standard might be appropriate. Thus, the district court accepted Martin plaintiffs' argument that Section 99's bar on the secret recording at issue should be evaluated under intermediate scrutiny, which required the district court to determine whether the bar is narrowly tailored to serve a significant government interest. The district court also noted that for a law to survive intermediate scrutiny, it must leave open ample alternative channels for communication. On appeal, the district attorney challenges the district court's decision to apply that level of scrutiny by referencing precedents applying forum analysis to evaluate restrictions on expression. She notes that the category public spaces incorporates not only traditional public fora, like public parks, but also limited and non-public fora, such as the shoulders of highways and certain areas of public buildings, like the site of the recording at issue in Ayakubuchi. Ayakubuchi, again, was where he was recording in the city hall in the hallway. But, as she points out, the intermediate level of scrutiny that applies to content-neutral restrictions on expression in traditional public fora, applying, or see Cutting versus City of Portland, gives way to a lower level of scrutiny when we evaluate such restrictions in other fora. See American Freedom Defense Initiative versus Mass Bay Transportation Authority, asking if, as to non-public fora, whether the restrictions are not viewpoint-based and are reasonable in light of the purposes for which the forum was established. For that reason, the district attorney contends the district court erred in applying intermediate scrutiny to Section 99's bar across the board, as by doing so, the district court failed to attend to the differing locales in which the planned recording would occur, and thus required the government to satisfy a degree of fit between the ends and the means it was unnecessarily demanding. Neither Glick nor Gericky, however, purported to predicate the level of scrutiny that applied to the challenge recording restrictions on forum analysis. So what they're saying is Glick and Gericky never made their level of scrutiny based on the forum. They didn't care that it was a non-public forum for Glick, or for Gericky. They didn't care that it was a public forum for Glick. And while the Supreme Court has not addressed a challenge to a prohibition against secretly, or for that matter openly, recording law enforcement, there is no indication in its precedent that the forum-based approach that is used to evaluate a regulation of speech on government property, see International Society for Christian Consciousness versus Lee, or, to put it in the plot holes language, Kirsten versus Lee, I'm just trying to be inclusive, necessarily applies to a regulation on the collection of information on public property. See these things. Public forum principles are out of place in the context of this case. See also, we expressly declined to apply forum analysis in this case. And see this case, noting that the court's limited forum cases were related to, but did not control its subsidy cases. Compare March versus Mills, applying forum analysis to a statute that restricted noisemaking even in public parks and other traditional public fora. With Pleasant Grove versus Summum, as a general matter, forum analysis simply does not apply to the installation of permanent monuments on public property. Nor does the district attorney offer anything beyond assertion as to why forum analysis, in a strict sense, applies in the context of the right to engage in the news gathering involved here. The application of intermediate scrutiny also accords with the approach that we took in Glick and Gericky, even though neither case explicitly named the level of scrutiny deployed. Indeed, the district attorney, by repeatedly emphasizing that the facts underlying Glick took place in a traditional public forum and conceding that the intermediate scrutiny pertains in such a setting, implicitly recognized that we effectively applied that level of scrutiny in Glick. See Glick, recognizing the right to record may be subject to appropriate time, place, and manner restrictions. See also Rideout, citing Ward, a case about time, place, or manner restrictions, and articulating the inquiry for intermediate scrutiny. See McGuire versus Riley, describing the level of analysis that applies to time, place, and manner restrictions as intermediate scrutiny. And while Gericky was no more expressed than Glick in naming the level of scrutiny applied, it purported only to be following Glick, despite the fact that the recording there did not occur in a traditional public forum. Finally, the intermediate level of scrutiny the district court applied roughly tracks the scrutiny applied to restrictions on news gathering in other locales to which the public generally has access to collect information. This correspondence reinforces our conclusion that we have no reason to depart from the district court's approach here. See Press Enter versus Superior Court, Supreme Court decision, holding that a criminal proceeding may be closed to protect the accused's right to a fair trial only if doing so is narrowly tailored to serve that interest, meaning that there is a substantial probability that the defendant's right to a fair trial will be prejudiced by publicity that closure would prevent, and that reasonable alternatives to closure cannot adequately protect the defendant's fair trial rights. Also see these other things. And then they're going to go and review it based on intermediate scrutiny. But I found this case to be interesting because I had always assumed, along with the District Court of Colorado, that it was a public forum analysis. But apparently it's not. It is, at least according to the First Circuit, it is its own intermediate scrutiny analysis, and based on that, it would be subject to reasonable time, place, and manner restrictions, but that might be the analysis that you'd have to use in a public building. If the rule that's applied is across the board, like this eavesdropping law, then you'd have to analyze that law according to intermediate scrutiny to determine whether or not that could be what would prevent you from filming in a public building, assuming there is no other law in place on it. And for those of you who think that it's kind of like a weird thing or an odd thing that you can film, that you have a right to film, at least at some times in some places, there is this is Smith versus Cummings, and obviously it deals with filming police in the performance of their duty, traffic stops and things like that. But there's Blackstone versus Alabama, where they found the plaintiff's interest in filming public meetings is protected by the First Amendment. It was a Child Support Commission meeting, and the chairman of that restricted, I believe it was audio recording. No, it was audio and video recording, and the court found that no, you had a First Amendment right to film that. There's another one, Thompson v. City of Clio. Thompson was audio recording with the tape recorder, and the mayor forbade him from audio recording, and that was an impermissible. I think that was both a content and a viewpoint-based restriction. So Thompson had the right to film there. We talked earlier about Io Kako, whatever. That one was where a news reporter, independent journalist, gathering content for a story, was recording outside in the hallway of the town hall, outside of a town hall meeting after it was ending, and he had the right to film. So there are lots of cases out there that have held that you have a right to film in certain governmental buildings under certain circumstances. And as far as a city hall being a limited public forum, I know that Sheets versus the City of Punta Gorda they determined that it was a limited public forum, but they did it because the parties agreed that it was a limited public forum. see right here. Here, the parties agree that it's a limited public forum. So the court did not necessarily come up with that particular notion itself. And there are lots of cases out there where, for example, a governmental building has multiple areas in it. So, like, portions of it might be a courthouse and have court facilities. Other portions might have the county recorder's office. Other portions might have city hall in it. And just because it's all under one roof contained within the same four walls doesn't mean that the analysis is going to be the same in each one of those areas. For example, a court has the greatest right to limit your First Amendment activity inside the courtroom. There's no place really where a free person, a non-prisoner, has less of a First Amendment right or has the most restrictions on their First Amendment right than in a courtroom. The judges have a lot of control because of the need to effectuate justice there and to maintain decorum, etc. The judges have more control in the courtroom than any other place. And if you step out of the courtroom and you get into the halls and the common areas surrounding it, there's less potential for a restriction. And if you get out of those into like a part of a governmental complex where there's like the city hall, they might have city hall meetings, they might have council meetings and things like that, where you might have a right to record. I mean, like if they're recording it and they're making the recording available, you probably don't have a right to record unless there's going to be an analysis basically of it. But there's not necessarily one single forum analysis for that government building. Part of it might be a designated public forum. Part of it might be a limited public forum. Part of it might be a non-public forum. Part of it might have been held out to be an area for expression since time immemorial. I mean, if it's one of these really old courthouses, maybe they have a room in it that has just always been used for public expressive activity, and it's always been allowed there. And so based on that one room might be a traditional public forum. So all I'm saying is that it's a little more complicated. You can't just say you don't have a right to film in a government building. You can't just say that a city hall is a limited public forum. You've got to go through the steps. You've got to go through the analysis. So I hope this was helpful. I hope you learned something today. Thanks for watching. Have a great day.